Hi, everyone. I think we're going to get started soon, or we can actually get started now, it looks like. So my name is Catherine Pfeiffer. I'm an associate in the International Litigation and Arbitration Department at Foley Hoag, who has been part of a team advising the Global Justice Center on their work on the impacts of the Dobbs v. Jackson Women's Health Organization decision. And to that end, on March 2nd, 2023, the Global Justice Center, along with Pregnancy Justice, the National Birth Equity Collaborative, Physicians for Human Rights, Human Rights Watch, and Amnesty International, spearheaded a submission to a group of UN Special Rapporteurs about the impact of Dobbs on the United States obligations under international law. And this submission was signed by more than 190 organizations. Today, April 18th, 2023, the Global Justice Center, Pregnancy Justice, the National Birth Equity Collaborative, and Physicians for Human Rights are publishing a briefing paper that highlights original research and physician testimony from that submission. To launch this paper, we have convened some experts from some of these organizations for this webinar to discuss the briefing paper's landmark investigation into the unprecedented crisis unleashed by the Supreme Court's ruling in June of last year. I'm going to briefly introduce our panelists, and then we'll jump into questions, followed by an open Q&A session. Folks, it would be great if you can add your questions to the Q&A function rather than the chat. We'll be monitoring that, and then when the time comes at the end, I will ask the panelists those questions. So first of all, we have Dr. Christine Ryan joining us. She is the legal director of the Global Justice Center, where she directs the team's legal work and feminist advocacy. Christine is an international human rights lawyer, a scholar, and expert on law and gender. We also have Lauren Ranowski with us today. She is a social worker and policy and program associate at Pregnancy Justice, where they lead legislative advocacy to oppose the surveillance and criminalization of pregnant people and their families. And finally, Susie Abdu is a senior transnational policy advisor at the National Birth Equity Collaborative. She is a foreign policy expert and international development specialist on democracy, governance, and gender with extensive experience in the Middle East and North Africa. So to begin, I want to thank you all for being here with us today and for putting so much work into the submission to the UN Special Rapporteurs and the briefing paper that is launching today. I would like to begin with a general discussion of the impact of that submission, where you can all share your remarks. So please tell us a little bit about the background of the submission, its significance, and its purpose. Maybe Christine, we can start with you and then go to Susie and Lauren.
Great, thank you, Catherine, and thanks so much to all of you who have joined online. We prepared this submission, the organizations you see before you, along with other partners, including Amnesty and Human Rights Watch and Physicians for Human Rights, in response to essentially the human rights crisis that was unfolding post the Dobbs decision and the multiple abortion restrictions that decision has enabled. These restrictions are causing women, girls, pregnant people to be met with systemic refusals of reproductive health care, forced travel and very onerous financial burdens to access reproductive care, serious stigmatization, fear of violence, fear of criminalization, with huge ramifications for people's human rights to life, to health, to non-discrimination, to be free from cruel and human degrading treatment, their right to privacy. And essentially what we set out to do was come together as organizations to document what our respective organizations were seeing, and to do so in a human rights frame to outline that the US was in violation of multiple international human rights standards. And as you heard, sent this submission to UN Special Procedures, a body that has the capacity to engage directly with the state to encourage compliance with international human rights. I'll pass it over to my colleagues so that they can give some insight on the parts of the work that they found motivating and their substantive expertise as well in doing this.
So Susie, maybe we can hear from you next.
Sure. Hi, everyone. Thank you for attending, and thank you to my colleagues for inviting me to participate. I am with the National Birth Equity Collaborative, and my role is really on transnational policy. And so when we look at this paper, what we're addressing really is accountability by the United States with regards to the ramifications, or what we've heard referred to as the chilling effects, that these kinds of overturning this kind of protection has around the world. And the United States being a global hegemony, being the leader of the free world, really, when we make this kind of decision, we see that the rise in populist governments, nationalist governments take advantage of this opportunity that this leading country has made this kind of decision. We see that it's in line with laws that we're seeing passed in Hungary and in Poland. It allows for countries in Central America, such as El Salvador, to dig their heels in on existing laws with regards to women who have miscarriages, let alone criminalizing women who have abortions. And so the United States, the way that we see it as NBEC, does not work in isolation, but if anything, has quite a significant role in the impact that our decisions have around the world. And so that being a segue and to what Dr. Ryan was saying, which is that this kind of brief allows for us to hold our country accountable, as it is a signatory to multiple treatises, which I know Dr. Ryan will bring up, and I'm sure that Lauren will bring up, that are involved. And so the way that we saw it as one of the partners is that if we have to hold the United States accountable. And if our government represents the people and distributes foreign aid for family planning, then we have to hold our country to the standard that it's set for itself and how it represents the will of the American people abroad, which is something that I'll talk about a little bit later. And that these kinds of briefs are a necessary exercise in advancing America and the rest of the world towards fundamental freedoms and human rights for all people. And so that's really how we see the importance of this brief and its timeliness.
Thanks very much, Susie. Lauren, do you want to add your thoughts to that?
Yeah, thank you all for inviting us and me to speak with you all today. I think that we really found it important to stand with our national allies and amplify this issue on an international stage. We typically work at the national level, but we think it's important for the world to tune in and understand what has been happening in this country as far as attacks on bodily freedom and the right to safely parent. We think that this submission really properly demonstrates many of the critical implications of the Dobbs decision, including, implications for medical providers' ability to provide care and threats to digital surveillance. Additionally, with regard to our work, we do believe that the Dobbs decision will incite an increase in surveillance and criminalization of birthing people, as has already been happening for pregnancy loss and for people who have even a healthy birth. We do think that this case is consistent just with the overall trend of trying to decide who can parent, particularly Black women, as it relates to historical contexts, that relate to the war on drugs and substance use during pregnancy. We think that this is a really good opportunity to bridge the gap across all reproductive justice movements and show that it can be an and, right? It can be pregnancy of criminalization and it can be criminalization of abortion, and how it all is inherently the same strategy. And so we can look to the past as ways to sort of combat where we might be headed in the future.
Thanks very much, Lauren. Before we turn to the international law aspect of this, I'd like to discuss some of the impacts of Dobbs, which some of you have already prefaced in your remarks, and which is contained in the briefing paper that we're launching today. So, Susie, can we start with you? I would like to ask you about the impact of Dobbs on marginalized populations, which I know is linked to the work that you're doing.
Sure, absolutely. I would like to begin by saying that the National Birth Equity Collaborative does focus on the Black population or birthing people of African descent, and that we do a lot of work within that, and addressing systemic racism and colonialism, prevalent colonialism that still exist in U.S. law and abroad, in the way the U.S. as an actor abroad. So I'd like to begin by talking about just a handful of points that are really important with regards to how this overturning of Dobbs affects marginalized groups, which are already disproportionately impacted by poverty and systemic racism, climate change, violence, crime, and all that this kind of decision does is that excuse me, compound these issues and even add to them. So where we see already reduced access to healthcare and people facing socioeconomic and race and barriers such as racism, there are communities that already lack comprehensive sexual education and have poor health outcomes. Now we've made it so that the rates of things such as maternal mortality will increase. The health and financial ramifications of banning abortions and safe abortions will have a huge impact and will aggravate these existing conditions. So for instance, a birthing person who's forced to carry to term in these marginalized communities, it's a fact that there are people who are going to die. Another example is that low-income birthing persons already face limitations of Medicaid and adherence to the Hyde Amendment. 2/3 of the birthing people currently enrolled in Medicaid are of reproductive age. So there is a high likelihood that they will be affected by this decision. Also, and you can tell me also, Catherine, if when my time is up, I don't want to take up too much time from the others because this is such a large subject. Secondly, those who could previously circumvent the laws in their states, many now won't be able to from these communities due to distance and transportation that are already barriers to access. And we're seeing in some states are even being criminalized. 1/3 of birthing people already live at least an hour from their nearest abortion provider. And in our brief, we point out that Dobbs will increase that distance 3-fold. And that one of the many factors that contribute to this distance is that there are clinics that would offer abortions that are now being forced to close as a result of the Dobbs decision or the overturning of Dobbs. And also seeing that there are many states, Florida, Ohio, that have said that there won't be exceptions for incest and victims of sexual violence. And violence, family issues are quite high in marginalized communities and communities that are affected by poverty. And so the lack of exceptions even will have a greater impact on the physical health, mental health, access to education, and economic opportunities in the future, particularly for girls who are impacted by pregnancy as a result of incest or sexual violence. I know that some of my colleagues will be talking about the kind of fearful environment that will exist for providers, health providers. So you have, for example, pharmacists in Nebraska and Georgia that denied patients medication to treat a miscarriage. The majority of Georgia, the vast majority of Georgia is rural. And so what access will these women have in rural areas? And we know that birthing people that live in rural areas, it's not just a distance and transportation, but many other factors that make them, according to the CDC, they have the highest likelihood of pregnancy-related deaths. And so these kinds of situations that we put our healthcare providers in, our brief also references Wisconsin, where doctors wouldn't remove fetal tissue from a patient that had an incomplete miscarriage. The immediate and lifelong health and psychological impact increases for patients, for these patients. And then finally, these federal decisions allow for state-sanctioned, racially motivated policies to grow and persist. These are communities that already face racism and discrimination in healthcare as it is, as I mentioned, persistent stereotypes, stigmatization, blaming patients, viewing certain groups as or deeming them unworthy or incapable, makes it so that that racism within healthcare will persist. If we think about issues like delaying care, if it can happen to, people like Serena Williams when she gave birth, delaying care to her, then can we imagine what happens to Black birthing people and how prevalent the issue is for them when they don't have the kind of access and wealth that Serena Williams would have. So what we're essentially doing is we're trapping these communities in a hostile cycle that will make it even more difficult for them to break out of it. And that is, of course, a major issue. And more children, we're making it so that more children will be raised in poverty and exposed to the kinds of inequalities that occur within these marginalized communities.
Mm-hmm. Yes. Yeah. Thank you, Susie. That's all really powerful. And I want to turn to Christine now and talk about the United States international obligations on racial discrimination, which is related to everything that Susie just said. So Christine, can you tell us a little bit about those and also how the trends that Susie identified have and are impacting these obligations?
Thanks, Catherine. So the US is party to a number of international human rights law treaties. And just to back up a little bit, one of the motivations in doing a report like this is because for the first time in about 50 years, our movement is contending and attempting to advance standards on reproductive health untethered to a right to abortion within the US Constitution. But outside of that context, we do have protections under international human rights law. And it's really important to remember that as month by month, we're seeing more and more states criminalize what is a human right. The US is a party to the Convention on the Elimination of Discrimination against Racial and Ethnic minorities. And what within the third convention, unlike under the US Constitution, there is protection for the right to health. And that includes the right to sexual and reproductive health. And the CERT committee has been very clear about that, in particularly when faced with documentation of the extensive harm that's being caused to people of color throughout the US owing to restrictions on abortion. And that's been as recent as last August, the Committee for the CERD Convention, so they're a body of experts who oversee implementation of the CERD, they clarified that and asked the state what they were doing to ameliorate the impacts on pregnant people of color and other birthing people, and women and girls more broadly, who even before they become pregnant now are facing restrictions in access to healthcare. Of course, we've also horrendously, and as Susie previewed, seen violations of the right to life. And that is increasing with the increased risks from obstetric emergencies, the already pre-existing high rates of maternal mortality that are higher in the US than any other developed country. And crucially, what many of our organizations see as almost at the crux of the issue of reproductive rights is a violation of non-discrimination. And that's on the basis of race, gender, socioeconomic status, for some based on migrant status, and of youth. And what the Human Rights Framework allows for, more so than the federal laws and state laws that have been available to advocates and have been used by advocates, is for that intersectional lens where you understand that the whole person and all of their freedoms are impacted by these parades of horrendous legislation and decisions at both the federal and state level. Now, this was recently summarized by the Working Group on Discrimination Against Women and Girls, where they clarified how sexual and reproductive rights, they're clearly established under international law, an integral part of numerous civil and political rights that underpin the physical and mental integrity of individuals and their autonomy and agency, such as liberty and security of person, freedom from torture and other cruel and human degrading treatment, privacy, respect for family life, economic, social, and cultural rights, such as the right to health, education, the right to enjoy the benefits of scientific progress, and the cross-cutting rights of non-discrimination and equality. Now think of that huge range of protections that we are all entitled to by virtue of our humanity, and compare that with the horrendous consequences of the Dobbs decision and the reaction from the present administration and from numerous state legislators. These are rights that we're entitled to, and that in doing this work, we're highlighting how the US is failing to uphold those obligations. And the third is a particularly important lens to apply, because as Susie has spoken to, the impacts of the denial of reproductive health care disproportionately fall on people of color.
Thanks, Christine. Lauren, turning to you, I want to pick up on something that both Susie and Christine mentioned, and that was the criminalization of pregnancy. So this is something that we know existed before Dobbs, but is getting worse in this post-Dobbs or also post-Roe world we're now living in. So Lauren, can you tell us what's meant by the criminalization of pregnancy, its history, how it's been used, how it's occurred, and also what's happening now?
Yeah, of course. I think that's a really good level setter to say, what do we actually mean by that? So we understand pregnancy criminalization as like in one of two ways. So the first would be any action or any inaction taken during pregnancy that leads to a criminal charge. And the second way we understand it is criminalizing something that would otherwise be considered legal if the person wasn't pregnant. And so in that case, we're essentially like the criminal charge is two components. It's the action or inaction, and then it's the state of being pregnant. And so if that state of being pregnant wasn't there, then the criminal charge wouldn't happen. And so therefore it's impartially at least criminalizing that status. We have started to track this issue in part because of our founder, Lynn Paltrow, who did a lot of work early in her career on cases like Ferguson, which related to unconstitutional drug testing of Black women in hospitals, and in other instances of increased surveillance of pregnant people. And so due to her observing that trend, after the Roe decision happened, she was looking forward to see where might the opposition go next. And so she decided to start tracking this issue. And so one of our first studies was took place from 1973 to 2005, in which we found 413 cases of arrests or forced deprivations of pregnant women, which to some people that might seem high and to some people that might seem low. We know for one thing for sure is it is an undercount. We have a tremendously difficult time truly tracking the magnitude of this problem. But even more alarming is, since we've replicated this study, which would take place from 2005 up until the Dobbs decision, we have already seen triple the number in just half the time. So we have nearly 1,400 cases now. And so, you know, how is it prevalent now? And as I mentioned before, we really do believe that the opposition will use a very similar playbook in respect to criminalizing abortion that they use to criminalize other pregnancy outcomes. And for example, as it relates to data privacy, in our prior cases, we did see folks' digital footprint be surveilled by law enforcement to aid a criminal investigation. And so that is a major concern that isn't necessarily even hypothetical, right? We have actual cases where this has happened. You know, just based on our preliminary analysis of this new study, we do believe that it will most of the criminalization will still impact patients the most. There is a lot of concern, rightful concern for medical providers about what their true risk is. And I think this brief really accurately represents that. And we are also concerned about what criminalization might look like of patients seeking abortion care. Our new study will be published in the fall, which will be able to analyze the post-Dobbs information, so maybe more concrete trends than what I can provide right now. If you're curious about sort of abortion criminalization specifically, If, When, How has a great study that they've published their preliminary findings on that I can drop in the chat, since we do believe that our numbers will be pretty short as far as the abortion goes. So yeah.
Thanks, Lauren. You mentioned the criminalization of abortion care, so healthcare workers, doctors, nurses, others involved in that process. So I wanted to ask Christine this. This is a question, if you can maybe expand a little bit on the criminalization of abortion care. I know in the briefing paper, we spoke to a number of OBGYNs who were performing abortion, for example, in Texas, when they had what was termed the Heartbeat Act, and in other places where abortion was otherwise restricted. So maybe you can tell us a little bit about what that looks like and how healthcare providers are navigating this new environment.
Thanks, Catherine. Yes, so what we have been seeing, and this, was essentially no surprise based on how abortions play out in the rest of the world, is that restrictions on abortion, particularly the threat of criminal sanction, even if it's not being enforced immediately, places an extreme chilling effect on the availability of care. Even for those who are experiencing serious pregnancy related complications, providers are in such a situation that they feel gagged by these laws, to the point that sometimes they are withholding information from patients for fear that their medical advice, based on best medical evidence, could violate a state's anti-abortion statutes. Doctors have reported that, the rapidly shifting landscape, which we've seen, it's often very difficult to communicate what is legal within the parameters of a state's law on time and with enough confidence to providers such that they don't feel the need to be so careful. Because this is what happens in this ecosystem, is that criminal sanctions and criminalization of abortion, it leads to fear, stigma for those who are trying to access care and those who are trying to provide it. What doctors also have, they first and foremost, I think the ones that we spoke to, emphasize that their biggest concern is about their patients' medical safety, and they always worry about that. But they're also worrying about their legal safety, their patients' legal safety, and their own legal safety. And this is just so contrary to what normal patient care should look like. We also feel we've also uncovered that some hospitals that are particularly risk adverse, even where there are exemptions in the laws, but again, these exemptions don't work because of the type of stigma that they generate, but they're failing to give healthcare teams the information that they need to feel comfortable making decisions without putting themselves and their patients at legal risk. In addition to the fact that how systemic this chilling effect is becoming. So in so many cases, doctors want to feel, and other healthcare providers, they are willing to stipulate, that the patient's condition falls under a medical exception. But because there is so much bureaucracy in the hospital, or they need more than just themselves to carry out this care and don't want to put the rest of their staff at legal risk, they might face difficulty in assembling the necessary medical team to carry out the abortion due to the reluctance from staff or even the suppliers of medication. And these multiple regulations targeting both physicians and healthcare workers and those who provide care and assist in the provision of care. And just one last thing is that from our perspective, it is quite clear that the fact that these state level bans ostensibly have exceptions, whether it's to safeguard the health or the life of the pregnant person, these exceptions are unworkable, and they were designed to be unworkable. It's not possible to have exceptions that will list a whole range of medical conditions that might qualify somebody for a health-threatening condition. And the legal landscape really means that they're unsure about what qualifies as medically necessary or even life-saving. Physicians aren't lawyers, but even lawyers examining some of these exceptions are looking at non-medical terms, and that's also creating a level of risk. This is extremely dangerous. Both where we have seen cases where women were denied care and had to travel in emergency situations hundreds of miles for life-saving abortions, and that will continue to happen. But it was entirely foreseeable that this would happen. For decades, there is data demonstrating the chronic unworkability of abortion prohibitions with exceptions, whether it's to save the life of the mother is often inserted in these statutes, or for medical emergencies only. And I think that's important to keep in mind throughout this whole landscape, in that an advocacy around healthcare and abortion advocacy, because our human right to access abortion should not be prohibited in this way. And this is exactly what these restrictions are designed to do, is to create total barriers while allowing for the sense that, these legislators are possibly becoming reasonable because they're allowing for exceptions for health and life.
Thanks, Christine. Before we move on from this topic, Susie, I wanted to get your thoughts on, specifically from your perspective as working at the National Birth Equity Collaborative, how is this criminalization affecting the Black population?
Sure. I think that in terms of not just the Black population, although we work with that, and BIPOC communities that are already facing, again, criminalization and issues with the system, and with I'm losing the word, of course, when I need it, but having to go to jail in higher populations of African Americans within the system, that this just aggravates it. And if we think about what Lauren was talking about in terms of surveillance, who is going to be affected by surveillance first? It's going to be these communities. When we think about, for example, Texas trying to pass surveillance laws, right, that would where they attempted to have it so that if someone is aiding a birthing person to get to their abortion appointment, then that person can be charged with aiding and abetting. Who is going to be surveilled first in conservative communities and rural communities, areas that are already racist? It's going to be the African-American community. It's going to be Black people. It's going to be people of African descent, and then of course so on from there. And so I think that that's the first place that we're going to see surveillance that leads to criminalization, is going to be with these communities for those reasons. Places like Louisiana, Alabama, Missouri that are also looking to do so, and what happens in those communities, especially in rural areas. And I think one point I'd like to make is that it's the marginalized groups that will suffer most from this, of course, invasion of privacy. And what it does is that it creates suspicion among people, as opposed to promoting communities that care for one another. And this affects also just the fabric of our society, is what kind of country do we want to have? What kind of communities do we want to build? And are we undermining existing tensions between law enforcement and these communities by allowing for further criminalization based on healthcare and access to healthcare when overturning these kinds of laws? Are we considering, again, how these laws impact existing and exacerbate existing issues within BIPOC communities?
Thanks very much, Susie. I wanted to turn now more to looking at this from an international law perspective. Christine, I think we already heard from you mostly on how the U.S. is in violation of its international legal obligations, and also why it's important to think about this in an international human rights framework. But maybe if you have any additional comments on that, as well as I wanted to get your thoughts on how this approach to human rights, the United States approach to human rights, where it is essentially taking a hypocritical approach by requiring human rights of other countries, but not really upholding it at home. I also wanted to hear your thoughts on that, as well as the trends that we're seeing elsewhere, where the rest of the world is liberalizing abortion and the United States is restricting access to abortion.
Thanks for the question. It's something that we talk about an awful lot at the Global Justice Center, is, knowing that this hypocrisy exists. It's, how long is it before everybody sees that the level of hypocrisy is unsustainable? And I think what is often missing from, the conversation that points out the disparities between what the US preaches about democracy and human rights and practices on democracy and human rights, is that it was by design that the US has taken this posture of US exceptionalism to international human rights law and international law more generally. When numerous international human rights law treaties were being negotiated, the US government began to become quite nervous of the rights that were being articulated, including from, insertions from a number of global South countries talking about economic and social rights and political equality, including for minorities, because at the time, this is in the post-war era, the US was in the midst of in a deep civil rights crisis. Arguably, it still is. But at the time, there was a concern among those in the administration and those who had power that these rights could be weaponized, and rightly so, by communities who were seeking racial equality. And this is, very well documented and researched by a number of Black scholars. I say Carol Anderson in particular, who really show how the US was successful in downplaying the role of international human rights norms domestically, because it was nervous about how and the potential for groups like the NAACP to start making these claims. And their strategy could have gone either way, but the US itself was really, really successful in downplaying the relevance of those norms domestically, while still being able to take a role on the world stage in creating these norms. So in terms of what we think about, in very knowledgeable and aware that there is a hesitancy to embrace international human rights in struggles domestically, we think about the utility of these norms in terms of the methodology that exists, in terms of their role in social movement framing and imagination, and also as a resource in calling for accountability and looking at entities beyond the federal court system, and thinking about how legislators, how companies, how healthcare providers themselves can be motivated by international human rights standards. And we take a lot of our inspiration in doing that type of work from other countries. There isn't a state in the world that hears a condemnation from UN experts and says, right away, okay, we're going to change everything. No less than the US. With any type of norm, whether it's internationally or even domestically, it depends on what we do as civil society, as rights holders, to hold those in power accountable. Not that I'm, wanting to put more work on anyone, and certainly not the partners that are involved in the webinar here. But that is our job, and that's how the enforcement of international human rights works. It's not a top-down approach. It's what we do at the national level to bring attention to these human rights violations and to pressure our decision makers to do better. So I hope I answered the question.
Yes, you did.
Let me know.
You did. I'm cognizant that we're getting close to the time I promised for Q&A. So I have one final question, and I think it segues nicely from what Christine said. And that is, and Christine, you already addressed this, I think, in your comments, but what role does the international community have in holding the US accountable? And also specifically from Susie and Lauren, I'd like to hear what do you think that US policymakers, US legislators should be doing right now? What can we be asking them to do right now? So maybe Lauren, could we start with you and then go to Susie?
Sure, yeah. I'll probably just address the domestic policy recommendations. I think first, the Hyde Amendment came up, and I think repealing that, I 100% agree with Dr. Ryan's points on that exceptions are not enough, and just the inherent unworkability of it, the confusion it causes, and that what is happening is we're seeing legislatures and judiciaries decide when medical care should and should not happen rather than the experts in the field. We think that it's also important to protect data privacy in your state, regardless of abortion access. Just in general, it's extremely important to protect that. And finally, just addressing the intersectional issues such as pregnancy criminalization, like I mentioned, maternal mortality, like has been mentioned, family policing or the child welfare system, and then other social determinants of health that greatly also, impact someone's ability to access healthcare, regardless of whether or not abortion is legal in their state. ultimately, we think that it's important that the U.S. government take heed from these recommendations and do something about it. And I think, I mean, at least from the federal government, the Hyde Amendment is a really good example of something that can happen to at least ensure broader coverage for abortion beyond, the exceptions in that.
Great, thanks very much, Lauren. Susie, let's end with your comments on this.
Thank you. I will try to be brief, but what I will say is one thing, more than one thing, that what we're seeing is really the influence of politics and social issues on legislation and the legislative process, and then putting a burden on the judicial system. So I would say that the first thing that U.S. policymakers need to do is put people first and politics second, that we need to listen to the people. The majority of American voters believe that abortion services should be available and accessible. And in a country where we have attempted in several administrations, presidential administrations from Clinton to Obama, to change what is, or to repair the US's broken healthcare system, yet it continues to be an issue, is only an indication that America can, but does not have the will to repair this system, because it preserves racial and economic privileges for some Americans and not others. And I think that is something that we address in this brief, and also in the some of the shadow reports for CERD, the Convention on the Elimination of All Forms of Racial Discrimination. What we are saying by not repairing the system is that there is a segment of the population that is dispensable for the purposes of the prosperity of another segment of the population, and that this hypocrisy and this is not only unsustainable, but also hypocritical. And lastly, that the very same things that we denounce about other countries will codify into our own laws. For example, we say that we should allow for education for girls in Afghanistan, where research is conclusive that girls with an education have more opportunities and more control over family planning, and improves the positive impact they have on their children. Yet again, we're seeing in Florida, Arkansas, Ohio, that exceptions can't be made for 10 and 12-year-old girls that can become pregnant as a result of incest, sexual violence, that school-age minors have to carry their pregnancies to term with total disregard for the impact that it will have on their health or ability to receive an education or plan for families in the future. And so to really point out to policymakers that we can't codify for into law for our girls and our birthing people, something that we denounce in other countries, and that going into an election cycle, the influence of politics and social issues on how we legislate and the decisions that we make really need to be secondary to what is a national and international crisis in terms of the overturning of Dobbs.
Thanks very much, Susie, and thanks to you all for those really helpful, insightful comments. I think that we have about 10 minutes for Q&A, and I have one question here in the chat, so I'm going to read this out. And I think any of you can answer it, would have expertise on this. So here we go. This is a question that says, are there any legal claims or tools, both under US federal/state law and international law, that US citizens and/or organizations can use to enforce their abortion human rights directly in an effective way that would get them the health treatment they need in a matter of hours or days? In other words, is there an urgent legal tool that can be used quickly to ensure women's life and health is protected?
I'm happy to take that, and particularly, and I guess one of the first things to say is that in constitutional law here, in federal law in the US, it's almost has been untested to a large extent, but also not recognized by the courts here, the implications of abortion bans for racial equality. But that's certainly an argument that is worth making, both in terms of the impacts of these laws on communities of color, and also considering the history of the United States and how reproductive autonomy and stripping Black women in particular of their reproductive autonomy was a method used by the state to control the Black population, and it really is a badge and incidence of slavery. So there are some groups and scholars working on that. I particularly would point you towards Michelle Goodwin, whose work on that is particularly strong, and others such as Dorothy Roberts in the international human rights framework. Racial equality is defined much differently than in the United States. There is an embrace of substantive equality, looking at outcomes, not just procedural equality of opportunity. And the definition of racial discrimination in the Third Convention outlaws the purpose and effects of requires states to tackle the purpose and effects of laws that cause racial discrimination. So in the US, as you might be familiar, there has been a extreme rollback in terms of how protections for substantive equality, particularly on the basis of race, have been decimated, essentially, even including by the present Supreme Court, and how they have successfully turned strict scrutiny into something that is eliminating protections for racial discriminations. It would be, thinking about the standards in international law and how you could transpose them domestically. I think, again, it's a case of working perhaps outside the Supreme Court, which for too long advocates have looked to as some advocates have looked to as a savior for fundamental human rights, but embracing understandings of equality like Black feminists, like the reproductive justice movement has been doing for decades, and really taking that seriously and requiring those who have power, whether they're in academic institutions, whether they're in NGOs, whether they have legislative power, to understand that what they're doing, if they want to seriously address reproductive rights in this country, that they have to embrace racial equality as a fundamental part of that.
Thanks very much, Christine. Lauren, Susie, do you have anything to add to that?
I feel that Christine covered that very well, and possibly covers additional questions that are being brought up.
Great. So it looks like we don't have other questions in the chat, but with the acknowledgement that this may open a can of worms and we only have a few minutes left, I wanted to, I thought we'd be remiss without addressing some of the recent really horrible legal and judicial developments we've seen. Specifically, I'm talking about the decision in Texas regarding mifepristone, and also Florida's recent ban of abortion after 6 weeks of pregnancy. So maybe, Lauren, we can start with you. Just a few minutes, we can just, I wanted to hear whether you think this is an indication of the direction we're headed in, or if there's, some hope on the horizon.
Yeah, I mean, I don't know if there is a ton of hope, other than we will have to wait to see what happens with the Supreme Court. I think that with the Texas case, if the lower court decision is ultimately upheld, it will make medication abortion significantly more difficult to access across the country. It's particularly alarming that the court is essentially disregarding hundreds of scientific studies proving the safety of the medication, the implications on the right to privacy, that the only way to enforce such a ban will be to surveil mail or digital communications. We're really headed in a territory where it seems that legislatures and judiciaries will have the power to disregard science in favor of their political agenda. Like the decision has been condemned by both the AMA and ACOG, which should mean something, right? As advocates, I think the hope would be that it forces us to rethink how we communicate with others who insist on denying scientific evidence. I think for a while, I would think that I could just provide a scientific study and like show this is a fact and that would be enough, but it kind of forces us to rethink how we do approach the opposition. With Florida, I think there are enormous implications, not only in Florida, but throughout the Southeast, as it has obviously been a safe haven for folks in restrictive states. And I think looking forward, the next state to watch out for would be South Carolina, where pro-life supporters are already urging the government and legislature to be more pro-life. And their new bill does that, and going even further to possibly instill a death penalty for illegal abortions. So I think what gives me hope, though, is this conversation and looking at more of an international human rights framework. It feels really troubling when you think of like, how can we convince lawmakers who might just like be so persistent in the face of however much evidence, but we have as a country signed on to these treaties saying that we will uphold these human rights obligations. And that's a different angle that I'm personally inspired by.
Thanks, Lauren. I think that's a great place to end it. And we only have 2 minutes left. Anyway, so I want to thank you all. Lauren, Susie, and Christine, thank you so much for taking the time to be with us and for your efforts on the submission to the special rapporteurs and the briefing paper. I have dropped a link to the briefing paper in the webinar chat for anyone that wants to read it. I encourage you to learn more about this and read it. And then we have also added a link to the websites of all of the organizations that were spearheading this effort. So we encourage you all to learn more and to reach out with any questions. Thanks so much, everyone.
Thank you, Catherine.